Can't be leaving you alone with some guy overnight, whether you're in love with them or not, and they've been to prison before.
I'm sorry for everything.
But why would you do it?
Like
2025 CR 001820302, State versus Juan Cruz. Can I have parties announced?
Ashley Jones for the state.
Christine Brown on behalf of Juan Cruz.
And are you Mr. Cruz?
yes, ma'am.
Counsel, have you received all discovery and did you review it with your client?
I have.
Court will find that the state is in compliance with discovery and there are no applications, correct?
There are none.
Mr. Cruz, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We waive the reading of the indictment. We did want to note that the state is moving to amend it, and we waive that 10 days notice attached to that amendment.
All right.
Yes, Your Honor. The state is moving to amend the indictment to reflect the correct spelling of the pseudonym name as well as the word pseudonym.
Mhm.
So we are just changing that. And then additionally, we are proceeding only on count 3.
And defense, you have no objections to those changes or the waivers?
I have no objections to those changes, and we waive the 10-day requirement.
And Your Honor, the word pseudonym is actually misspelled.
Okay. All right. Mr. Cruz, did you review the court admonishments with your attorney?
Yes, sir.
Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right. In count 3, you're charged with aggravated assault if it's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow that plea. If for any reason the court does not follow that plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand? All right, we can go off the record for a moment. Did you understand you have a right to jury trial?
Yes.
A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court, just one second, I'm sorry. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
Oh, no, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if you're not a United States citizen, by entering into this plea, you can be deported, denied naturalization, or the right to re-entry into the United States?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 3. They're asking that your punishment be assessed at 25 years in the prison. There's a $1,500 fine. There are no applications. There's to be Chapter 62 compliance, and there's to be no contact with the complainants. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions?
Yes.
No pretrial motions of that sort. No.
Then to count 3, how do you plead?
No contest.
State any evidence to support the defendant's plea?
Yes, Your Honor. The state would enter into evidence State's Exhibit 1 and all of documents.
No objection.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
All right. Anything you wish to say on behalf of your client?
Yes.
Yes.
And so the defendant, my client does understand the ramifications of the charges involved. It was very difficult in terms of assessing what was at stake here. We have entered a plea to avoid the inherent risks of trial. The client, we are just asking that the state follow this, that the court honors this agreement. This has been the result of numerous meetings with the state, going over the evidence, and the state has conferred with the mother of the child. And this is a conclusion that everyone is in agreement with.
That is correct, John. We asked for family and agreement, please.
Anything you want to say?
Just want to say that I'm sorry for everything.
But why would you do it?
Like in a way that
I'm sorry, what?
no, I would say like I'm sorry like for
Sorry for what?
like when for the pain that I for her and everybody, the not being a better husband to her, to my children.
Well, I mean, according to the stipulations, you're the boyfriend. You're not a husband.
Or boyfriend, yeah.
So how long did you know them before you moved into the home?
Like about a couple of months.
So you knew the mother for 2 months before you were moved into the home?
Somewhere around about 2 months.
Right. And how long after you moved in the home that you were allowed to spend overnights with just you and the complainant?
How long? Like
Yes. So you move into the home within 2 months.
because I would work at night. I'll come home. I'll work night shifts and 11 o'clock, 12 o'clock.
Well, they're saying this happened overnight.
Yeah. at night.
If I may interject, just regarding the facts of the case, since we're discussing this, my client had been on parole at the time these allegations were made. There was a parole hearing at which the mother of the testified, and during that hearing, she had stated that
Oh, okay. But I want to hear this.
she had.
I understand it's hearsay, but I want to hear. Yes.
And so this is what I had pointed out to the state when we were coming to this conclusion, this proposed amount. The mother was relying on him routinely throughout the course of their relationship to watch that as she worked nights. She works as a housekeeper at the Metropolitan Methodist, the hospital on McCullough. And so that was an aspect here where she had asked him to watch the kids.
So when did that
night.
start? When did it start that you were allowed to watch as somebody's boyfriend that has only been moved into the house for 2 months?
Like for me to watch her, like that was my girlfriend. We've been living like we got the house together. I'm the one that got the house, and
How did you meet her?
through Facebook.
All right, so you meet through Facebook, and when you meet through Facebook, does she already have children?
She already had children. She told me about her life story. How
Well, no. I just want you to listen to my questions and answer my questions. So you meet her through Facebook.
yes, ma'am.
She tells you she has children.
She didn't tell me at the beginning,
Okay.
not till afterwards that we started talking.
All right. And so when you met her through Facebook,
Yeah.
did you already have prison history, or did the prison come after you met her?
No, I already had her.
And so what did you go to prison for?
For burglary.
All right. So
Never had no.
did you tell her you've been to prison for burglary?
Yeah. Because her ex had.
So you tell her, you meet her on Facebook.
Mm-hmm.
She has, and you tell her that you've been to prison for burglary.
Yeah, I tell her.
And then she says, great, you guys move in together. Okay,
Your Honor, may the
Yes,
state
ma'am.
ask the defendant some questions?
sure. I mean, he gave it the right to remain silent.
Mr. Cruz, Isn't it true that you knew the child's mother for 9.5 months before you guys moved in together? Does that sound more correct?
Yeah, like man, pretty much something like yeah.
And isn't it true that she had her father living in that home as well?
Yes.
And isn't it also true that you guys met through friends and not on Facebook? Would that be more correct?
Yeah, like Facebook, because she knew my sister and all that.
So you guys knew
Yes,
each
of course,
other
yeah.
from people, not something that you met online.
Yeah, so
No further questions.
All right, anything else?
If I can briefly
Yes.
ask him, and was it your understanding that there were past allegations made against another family member in the house by the same child regarding sex abuse?
Questions, relevance.
Overruled.
yeah, her dad, her ex-boyfriend.
All right.
Dad, oh, her son.
The son, would that be the
Yeah,
that his
Jay.
brother?
They had brothers. She had said that her son had did something to her own son.
And then what was the outcome of that
She
allegation?
didn't say nothing about it. I always told her do something. She didn't want to.
And what is your understanding of her relationship with a man in a case where she was a complaining witness for continuous violence against the family?
Well, that was her ex, her baby daddy. She told me that they had got an argument and she hit him in the car and she ran over, he hit the bump and he was trying to put the car in gear and
What is your understanding of their relationship now?
they're gonna get back together. She could put him in prison for 4 years for domestic violence.
How do
He
you know
gets
that he
out.
was going to, how do you know that
She
they were
told
going to
me.
get back together?
She was talking to him. He will call her on
Okay.
three-way from people from prison. I was for a lot of arguing and I told her, why you talking to me? Like, I'll just leave. I'll leave the house. She was always arguing with me.
Okay.
I'll just leave. I didn't want to get in trouble.
No further questions.
Okay, thank you.
Redirect, or is that process?
Sure.
How, you don't know for sure that she's with the person who abused her, isn't that true?
I mean, she was talking to him through the phone. Like
Would
when
it
I,
surprise you to know that she has a restraining order against him?
yeah, but she would still get letters for her friends. He would send letters to her friends' houses.
Objection to inaccurate statement, a restraining order, would that be a protective order? I mean, that's.
All
to me,
right, if
that's
you could
important.
clarify your question.
Yeah, a protective order, Your Honor. Are you aware that there's a court order prohibiting him from talking to her?
Yeah, but and that's why I would tell her why she talking to him and he was still calling three-way.
No further questions.
And I didn't, that was one of the main ideas.
All right. Is there anything else?
Nothing further.
All right, as previously stated, the court is going to find you guilty of count 3. The court will sentence you to 25 years in the prison. Give you credit for any time served. There's a $1,500 fine. Time and money will run concurrently. Chapter 62 registration. There's to be no contact with complainants. There's to be no residing with minors. And there's to be no unsupervised contact with minors. Anything else with regards to sentencing?
Okay, Your Honor.
Nothing further.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So here's the thing. The fact that some people are not paying attention to their children doesn't excuse your behavior. I have no idea why people will hang their star to somebody who's been to prison, which I believe in rehabilitation. But when you have children, you can't believe in rehabilitation because you have to protect your children. You can't be leaving your children alone with some guy overnight, whether you're in love with them or not, and they've been to prison before.
Yeah.
And so I'm putting no residing with children because ultimately, when you're released from prison, somebody's going to see that you're registered.
Mhm.
You may or may not tell them, I didn't do it. They're going to believe it. They're going to allow you around their children because for some people, you're a great catch and they don't pay attention to their children. They don't recognize that, hey, this child is 100% dependent on me for their protection. I can't leave an adult male in the home because sometimes this is what happens, but that doesn't excuse your behavior at all. Do you understand?
Yes, sir.
And you are not allowed to reside in any household that has children in there when you're released from prison. So if you meet somebody on Facebook, if you reconnect with somebody and they have a child residing with them, you can't live there. You can't spend the night. You can't be over there. Do you understand?
Yes, Your Honor.
All right, thank you. It's calling 2019 CR 9517 and 2020 CR 6198, State of Texas versus Jesse Jason Gonzalez. Could I have parties announced for the record for the state?
Thank you, Wilkins, for the state, Your Honor.
Defense?
We're ready, Your Honor.
And your name?
David Levinson.
All right, and are you Mr. Gonzalez?
Yes.
All right, Mr. Gonzalez, I'm going to show you what's entitled Motion to Revoke Community Supervision and Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review those documents with your attorney? Did you understand them?
Yes.
Are you the same Jesse Jason Gonzalez who was placed on community supervision in 2019 CR 9517 for the offense of possession of a controlled substance, felony group 2, less than 1 gram, on October 29, 2019 for a term of 4 years? Is that you?
Yes.
And are you the same Jesse Jason Gonzalez who was placed on deferred adjudication in 2020 CR 6198 for the offense of unlawful possession of a firearm by a felon on July 8, 2020 for a term of 5 years? Is that you?
Yes.
State, are you proceeding on the same allegation in each motion?
We are, Your Honor, although we were going to also in the 2020 CR 6198, we're going to proceed on an additional, the allegation, violation alleged in the supplemental, motion today.
All right, well, I don't have the supplemental motion. Let me see.
Judge, we can waive that one, because I mean, if he's gonna plead on
Okay.
we don't necessarily need this.
All right, any objection to the state reading one allegation and the client, thank you, and the defendant answering for both motions? Defense?
No objection, Your Honor.
All right, state.
Violated condition number 5 in Bexar County, Texas, the defendant Jesse Jason Gonzalez did then and there fail to report to the supervision officer as directed for the months of December 2022 and January 2023 in violation of condition number 5.
How do you plead to that? True or not true?
True. And Your Honor, we waive the other violations alleged in both of the motions.
Any objections?
No objection, Your Honor.
All right, did you understand by pleading true to violation of condition number 5 and the cause number ending in 17? The court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to a $1,500 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
Court will find violation of condition number 5 true. And the cause number ending in 98, did you understand by pleading true to violation of condition number 5? The court could find it true, grant the motion, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is, Your Honor. We're asking that you deny the motion, continue the defendant in on both clauses, and then extends to follow the probation's recommendation, which is to extend the probation to complete the state ISF cognitive track, followed by ISP, Judge.
All right, why should I follow that? He's been missing. You want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. State your name for the record.
Jason Gonzalez,
Where have you been?
been in Uvaldi, Texas. I've been changing my life over there.
Well, I mean, changing your life is not forgetting that you have a probation. So what have you been doing in Uvaldi?
Working. I have a 7-week-old child. I haven't seen him.
All right, I don't understand why people decide to have children when they have cases hanging over their head. So you have a 7-week child that you have not seen.
Yes.
And where is this child located?
With the grandparents.
And where is that? Uvaldi?
Uvaldi, Texas.
All right, so if they're with the grandparents, that means they're not with the mother, so,
The mother's here in the crowd
oh, okay.
She's in
So why is she here?
to support.
What is she planning on testifying?
No, Your Honor. Your Honor, he wanted to also ask you if you would transfer the probation at some point to Uvaldi because he wants to move there with his family
To change my
and change his life. And he understands he needs to report and be clean. He'll only have, maybe a year left on probation to complete. And once he finishes this cognitive program, he's hoping that he will be able to complete.
Probation, what are you all recommending? I know people see him and they're like, he's so young, he weighs 90 pounds.
Your Honor, on the recommendation from the probation CSO, it does indicate extend to complete state ISF cognitive track followed by ISP. And that is on both his cases.
So has he picked up any new offenses?
Show me, not that we're showing.
So where have you been working?
MG's building material in Uvaldi, Texas.
What do you do?
Forklift
How long you been doing that?
for about the past 8 months already.
Judge, so I've been speaking to defense counsel, and he did need some time to think about it, Judge, but I explained to defense counsel told me that he explained to the defendant that this is sort of the end of the road here. He's got to do this ISF, he's got to comply, or we're going for the 5 years, Judge. So he understands, and I know he should have understood already, but the options here are limited. It's either the state ISF and compliance, or it's 5 years in prison. So I believe that he wants to try to.
All right, so here's my question for all parties involved. ISF in this case would be really a punishment, sort of, and to change his way of thinking, which it already should have been changed. But then is he going to lose his job in Uvaldi if he's waiting for ISF?
He's already been incarcerated, waiting for this hearing.
But no, my question
And
is
they're still.
he
holding-
going to lose his job?
Yeah, they're still holding my job. But I was supposed to be over there sometime when I get out, but they don't. I told them like 2 weeks, and they said.
Well, that
2
was the
weeks.
wrong thing to tell them.
So, whatever. And then, on behalf of my girlfriend, Megan Lopez, she's the one that has contact with them too, so.
He has support and family. His father's here. He's got a lot of brothers, cousins. He has a lot of family support. And me, I've known him his whole life. I've read him the Riot Act, and hopefully this is like the prosecutor said, his last chance. He knows once he gets out, he's got a report, he's
Yeah.
got a test, and
I mean,
he's
he should
pretty
have
much-
known that before. How old are you?
I'm 23 years old.
He's really close to finishing, and we're asking the court to give him this one last chance, and we'll see what happens. If I'm here again in a year, well, no. If not, we'll be in good shape.
And the reason why I moved to Uvaldi, Texas, to change my environment and for the people, places, and things that I wasn't. The reason why I moved to Uvaldi was to change my people, places, and things in my environment.
Well, I mean, that doesn't help. So, for example, changing people, places, and things. That's what they say when they're in NA and AA. But guess what? NA and AA also tells you that you are supposed to take care of your responsibilities. And you didn't take care of this responsibility because did you turn yourself in?
No,
Somebody had to go find you and pick you up.
He was stopped or he was driving and it was this traffic stop.
Mhm. And then you're not obeying the rules of the road. People get a little bit lax when they've been driving for a while.
I don't know if there was a conviction on the stop or not.
All right, this is what I'm gonna do. In cause number 2019 CR 9517. I'm going to deny the motion and terminate you unsatisfactorily. And then in 2020 CR 6198, is he able to be placed on GPS if he's in Uvaldi? I'm going to deny the motion, alternate amend conditions. And it's going to include parenting classes, GPS partial for 180 days, and it's partial for employment only. What that means is all you can do is go to work and go back home. And the way GPS works, if there's a barbecue, you're not even allowed to go into the backyard to get the plate
yes, ma'am.
or reach out the window. You understand?
Yes, ma'am.
Are we going to allow transfer to Uvaldi?
Yes.
Yes, Judge.
All right. And then there'll be a transfer to Uvaldi. And this is where your punishment comes in. Your probation is going to be extended for 3 years. Anything else?
No, Your Honor. Thank you very much for understanding and trying to give me that second chance to show.
All right, you better do better. All right.
Thank you.
Christopher Costa entered Judge Stephanie Boyd's courtroom carrying a plea agreement, but burdened by his history. Facing a third-degree felony for his third DWI, he risks up to a 20-year term if his prior offenses were proven. However, prosecutors modified their strategy. They advanced using only a single prior offense, limiting his maximum penalty to a decade behind bars and a $1,500 penalty. Costa admitted his guilt regarding the crime and acknowledged the sentencing enhancement. He forfeited his constitutional rights to a jury trial, to cross-examine testifying witnesses, and even insisted he verify every statement, every waiver, and each legal ramification. She accepted be entered evidentiary agreements, declared him legally guilty, and verified the sentencing enhancement. Yet, she chose not to hand down his penalty at that time. Rather, she requested a pre-sentence investigation and a substance assessment, providing him a 2-month window to demonstrate he qualified for probation status as an alternative to incarceration. His defense counsel requested a court appearance scheduled after April 10th due to a medical consultation. Judge Boyd approved the request. April 11th stood as a single date, a solitary opportunity, and a lone magistrate, Judge Stephanie Boyd, possessing absolute authority to terminate his personal liberty or offer him clemency. The judicial hammer struck. The countdown began.